Welcome to Civics in a Year, the podcast that makes civic literacy fast, accessible, and surprisingly engaging. In just 10 minutes an episode, we'll tackle one of 250 essential questions about American democracy, how it works, why it matters, and what it means for you. Whether you're a student, a teacher, or just someone who wants to better understand your country and your rights, you're in the right place. Civics in a Year is powered by the Civic Literacy Curriculum from the Center for American Civics and is produced in partnership with the School of Civic and Economic Thought and Leadership at Arizona State University.
Today's guest is Nelson Lund, Distinguished University Professor at George Mason University's Antonin Scalia Law School. Professor Lund is the author of Rousseau's Rejuvenation of Political Philosophy, A New Introduction, and has written extensively on constitutional law, including topics like federalism, separation of powers, and the Second Amendment. He earned his PhD in political science from Harvard and his law degree from the University of Chicago, where he served as executive editor of the Law Review. His career includes service in the U.S. Department of Justice, the White House Counsel's Office, and clerkships with Justice Sandra Day O'Connor and Judge Patrick Higginbotham. At George Mason, he teaches constitutional law and jurisprudence, and his scholarship continues to shape debates about the Constitution and American legal thought. Professor Lund, thank you so much for being here today. I'm excited to talk about the Second Amendment. So the Second Amendment refers to, quote, a well-regulated militia. Did the founders think that people had the right to keep and bear arms only if they were enrolled in the militia?
No, they didn't. But we need a little background here. Starting in the 20th century, there was been a lot of debate about an individual right versus a states' right interpretation of the Second Amendment. But that question never came up during the founding period. And in order to see why not, and why the founders were motivated to adopt the Second Amendment, it's helpful to go back to England. There's a long history of conflict over the use of military forces in English history. And the condominium, so to speak, that was eventually arrived at in England allowed the crown to raise armies only for foreign wars. And that had to be paid for by Parliament, which gave Parliament a lot of power over the crown. As for to preserve domestic tranquility and to repel sudden invasions, they came up with a cheaper alternative, which was the militia, which consisted of most able-bodied men who were required to undergo some unpaid military training and be available when the crown needed them to do things like suppress riots or that sort of thing, or a sudden invasion if that were to occur. Well, at our constitutional convention, people were very aware of this history, and they had a kind of sentimental attachment to the militia because it had been such an important part in preserving the rights of the people in England. And then again, to some extent, in the United States before we became a nation. So there was a distrust of standing armies in peacetime because as we had seen in our colonial history, the crown was apt to abuse the use of military force in dealing with civilian population. So there was kind of a sentimental or kind of romantic attachment or emotional attachment to the militia. But during the Constitutional Convention, the framers decided to authorize standing armies in peacetime and create federal control over the state militias. And they did this because of their experience during the Revolutionary War, where the militia forces had proved to be just not a sufficient means of national defense. Now, during ratification, this was a major issue because the Anti-Federalists were very worried about oppression by a powerful new federal government. Nobody knew how the new federal government was actually going to operate, and people were afraid that it might usurp the rights of the states and oppress the people. Now, the Federalists argued that this wasn't a serious risk, in part because the American people were armed and they would be impossible to subdue through the kind of military force that the federal government would be able to raise at that time in our history. Now, the Second Amendment was completely uncontroversial because nobody argued that the federal government should have any power to disarm American citizens. Since the Bill of Rights applied only to the federal government, the states were left with their pre-existing authority to regulate guns and other weapons as they saw fit. Now, as it happened, the states imposed virtually no restrictions on the right to keep and bear arms at the time the Bill of Rights was adopted or for many years thereafter. The few regulations that existed applied almost exclusively to the misuse of weapons, not to their possession, not to their being carried around in public. Because there were no federal gun control laws like those that we have today, there was no reason for people to talk about whether the Second Amendment would allow Congress to adopt such laws.
So if the founders, you say it wasn't controversial, if they didn't discuss the issue, like where can we kind of look for the answer in all of this?
Well, I think the first step is where we should always begin with the Constitution, is to read the language very carefully, starting with the prefatory phrase about the militia, which says a well-regulated militia being necessary to the security of a free state. Grammatically, this phrase is an ablative or nominative absolute. Such grammatical constructions do not modify or limit anything in the operative clause. Typically, they explain the purpose of the statement in the operative clause. The real command of the Second Amendment comes in that operative clause, which says that the right of the people to keep and bear arms shall not be infringed. The right of the people is the same terminology used in the First and Fourth Amendments to identify a right that belongs to individuals, not to the government. Now, the next thing to look at is Article 1 of the Constitution. Section 8 gives Congress almost plenary authority to regulate the militia. The Second Amendment does not take any of that authority away from Congress and give it to the states. Any such interpretation would have generated a lot of controversy, but that didn't happen.
So if the Second Amendment doesn't change the allocation of the authority over the militia, why does it talk about a militia at all?
Well, to answer this question, you have to recognize that the term well-regulated does not necessarily mean heavily regulated. It has a more general meaning, namely appropriately regulated. Something's well-regulated if it's appropriately regulated. Or to put it another way, it's not inappropriately regulated. And what the Second Amendment does is to forbid Congress to enact one specific category of inappropriate regulations, namely those that infringe on the right of the people to keep and bear arms. There was good reason to worry about this possibility. Under the broad authority given to Congress by the Necessary and Proper Clause of Article 1, Congress might have been tempted to seize people's weapons under the pretext of exercising its very broad authority to regulate the militia. So, for example, it might have said, all arms shall be stored in government-controlled arsenals, and people are not allowed to keep their weapons at home that they'll need for militia duties. The Second Amendment simply says that this sort of thing is forbidden. By forbidding certain inappropriate regulations, the Second Amendment fosters a well-regulated militia.
Hasn't the world changed quite a bit since the 18th century? So how does that make it dangerous to leave guns completely unregulated?
Well, the world has changed for sure, but that doesn't mean we need to misinterpret the Second Amendment. First, recall that it originally applied only to the federal government, so the states were free to regulate weapons as they saw fit. It was only in the 20th century that the Supreme Court started applying some provisions of the Bill of Rights to the states. But in 1868, when that amendment was adopted, there was very little regulation of weapons, mostly just restrictions on concealed carry. It's true that various changes in society have now made significant gun control laws politically popular, which was not the case in 1791 or 1868. So we're now faced with questions about the constitutional limits of the government's regulatory authority that just didn't come up when the Second and 14th Amendments were adopted.
So, how should we be thinking about those constitutional limits today?
I think the most important point to keep in mind is that the natural or inherent right of self-defense is at the very foundation of our political system. We can see that in the writings of John Locke, who was the true father of our Declaration of Independence. According to Locke, the natural law forbids us to harm other people and gives each of us the right to enforce that law by force if necessary. When we form a political society, we transfer that personal right of enforcement to the government, but we always retain the right of self-defense when the government is unable or unwilling to enforce the natural law. You can see this through an example. According to Locke, if someone steals your money, you ordinarily must rely on the government to punish the thief. But if someone threatens to kill you if you don't hand over your money, you have an immediate right to kill the robber. For the same reason, people always retain the right to resist a predatory government, including, if necessary, through a political revolution. The same principle was adopted by William Blackstone, the English jurist who was the leading authority on English law among founding-era Americans. He said that the right to keep and bear arms was an indispensable barrier that protects the fundamental rights of personal security, personal liberty, and private property. Blackstone emphasized that the right to keep and bear arms is derived from the natural right of resistance and self-preservation when the laws of society are insufficient to restrain the violence of oppression. Consistent with Locke's view, Blackstone drew no distinction between oppression by the government and by oppression by criminals from whom the government is unable or unwilling to restrain. Now, naturally, Blackstone recognized that the government may regulate the possession and use of weapons in order to prevent criminals from violating our natural rights to life, liberty, and property. But in order to determine which regulations are permissible, we have to ask whether the regulation unduly compromises the absolutely fundamental right to self-defense. So, for example, a regulation that sets up security measures that stop everyone from bringing a gun onto an airplane actually enhances the protection for the right to life. But that's not true when the government declares various public places to be gun-free zones without the kind of security screening that we have at airports. This kind of rule simply creates an invitation for violent criminals because they can be sure that law-abiding people will be easy victims in a gun-free zone, so-called gun-free zone. It's no coincidence that a very high proportion of mass shootings occur in these so-called gun-free zones. A better name, I think, would be helpless victim zones, and these zones violate the principles on which the Second Amendment is based.
So obviously we should be enforcing the Second Amendment because it's part of the Constitution. But when in doubt, should we err on the side of public safety then?
I would say that when in doubt, we should err on the side of public liberty. A robust respect for the right to keep and bear arms promotes the moral temper that befits a free people. Citizens who arm themselves recognize that their lives and safety are not a gift from the government and that they are claiming responsibility for their own freedom and security. The importance of this attitude was recognized almost 2 centuries ago by Alexis de Tocqueville in Democracy in America. While Tocqueville was cautiously hopeful about our future, one of his greatest fears was that democratic countries would succumb to a kind of soft despotism imposed through what we now call the administrative state. The spirit of the Second Amendment can help retard our nation's slide into the kind of moral and political stupor that Tocqueville warned us against. Instead of enacting useless and frequently counterproductive restrictions on the rights of law-abiding citizens, Congress could promote this spirit by exercising its almost plenary authority over the militia. During the founding period, virtually all able-bodied men were automatically included in the militia, and they were required to undergo a modest amount of military training. Under current law, the militia still includes almost all able-bodied men between the ages of 17 and 44, but the training requirement has been abandoned. Today, Congress could begin by removing the outdated exemption for women. Next, Congress could make training in the use of small arms a condition of receiving a high school diploma or being admitted to a college or university. This training would obviously be useful if the militia were ever summoned to deal with a sudden emergency. And it would be useful to many individuals, especially women, who would be less likely to fall victim to violent crime. But most important, training in the use of small arms would help instill a spirit of self-confidence and self-reliance in America's future decision makers. They're going to need those qualities if they're going to be genuinely responsible citizens rather than docile sheep or whining victims of governmental pettiness and indifference.
Professor Lund, thank you so much. I know we are going to do another podcast episode on Supreme Court cases. So if that's something you're interested in, it will be coming. But Professor Lund, thank you so much for taking the Second Amendment and distilling it into something that is easily understood by the general public. We appreciate it.
Well, thank you very much for having me. It's been a pleasure.
Thanks for joining us on another episode of Civics in a Year. If you enjoyed this episode, be sure to subscribe and share it with someone who cares about a constitutional republic as much as you do. For more episodes, resources, and updates, follow us on social media or visit us at civics.asu.edu. Make sure to check out the show notes for any relevant links. Special thanks to the United States Marine Band for their performance of the Stars and Stripes Forever. Let's keep building a stronger constitutional republic, one episode at a time.